Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, is the state ready? Defense ready? All right. You may call your first witness. You'll step right around here, please, ma'am. Clerk here will raise, if you'll raise your right hand, she'll place you under oath.
Good morning. There's a microphone, and if you can speak directly into it, thank you. Will you state your full name for the record, please?
Penny Allen Williamson,
Thank you. And will you spell your last name?
Williamson.
Thank you. And will you tell us your relationship to Mr. Jordan Knight,
He's my youngest son.
your youngest son? Okay. And Ms. Williamson, as you know, we're here today for the sentencing hearing, and I think this is the opportunity in which you may give your victim statement.
Okay. On October 5th of 2020, we lost our youngest son. On that day, my family and everyone that loved Jordan was given a life sentence. A sentence of sadness, heartbreak, emptiness, and will never be healed. A life sentence of memories that will never be made, words that will never be spoken. Jordan Blake Knight was a loving father, brother, and son. He was so kind-hearted and always wanted everyone to be happy. He has missed more than words can express. Curtis Day, I don't know anything about you or what type of person you are. I don't know if you care or if you even are listening to my words right now. But I look around and I see your family. I saw them at the last hearing, and I see them today, and I see the pain in their eyes as well. And for them, I am sad because I know they're feeling a loss as well. I want to say that I forgive you. I forgive you because that's what my Savior, Jesus Christ, says has written needs to be done. I have no hatred for you in my heart, only sadness. I am sad for everyone involved in this. Bad choices are made and lives are destroyed. I pray for you and your family during this difficult time, and I pray that you find the opportunity to have a relationship with Jesus Christ and to ask for his forgiveness, because his forgiveness is much greater than mine.
Thank you very much. You can step down.
Crouch, you may call your next witness.
State calls Miss Wendy James. Good morning.
Morning.
We state your full name, please,
Wendy James,
and spell your last name.
James,
Miss James, where are you employed?
with Tennessee Department of Correction, probation parole.
And were you asked to, or did you receive a court order to prepare a pre-sentence report in this case?
Yes, I did.
And which defendant is the report prepared for?
Curtis Dale Day.
And have you filed a copy of your pre-sentence report with the Cheatham County Court Clerk?
Yes.
Thanks. Excuse me. Ms. James, in preparing the report, were you able to take a comment or statement from the defendant?
Yes.
And has that been listed out in your report?
Yes.
Will you turn to that page, please? I am looking what I believe has been marked as page 3 of the pre-sentence report. Is that correct?
Yes.
And on that, is there a defendant's version that you recorded?
Yes.
And will you please read that for us?
During an interview with the defendant on August 7th, 2025, the following information was obtained. The defendant indicated he was selling drugs at the time of the incident, but that he never sold drugs to the victim in this case. He reported he never met with the victim and never spoke with the victim. He reported he was dealing with a female, Amanda Gober, and that she sold drugs to someone who gave the drugs to someone else, and that person overdosed and died. He reported he isn't even sure if the drugs Amanda had were the ones that he had received or she had received from him, because she could have been buying them from other people. He did admit to selling drugs, but could not confirm or deny that the drugs that killed the victim were the drugs that he sold.
Thank you. In preparing the report, did you have an opportunity to review the defendant's prior convictions?
Yes.
And will you turn to that page, please? Are we looking at page 4 of the pre-sentence report?
Yes.
And what convictions did you note that Mr. Day has?
He has 4 meth convictions.
Okay, and starting with the first one, what is the offense date?
12/2 of 2022.
And was that conviction out of the United States District Court?
Yes.
So a federal court?
Yes.
And it was for methamphetamines, sale, manufacturing, delivery, sale, or possession?
Yes.
And what was his sentence?
5 years.
And the second conviction, was that on November the 9th? Excuse me, not conviction, but what was the offense date for the second conviction?
11/9/2022.
What was the sentence?
5 years.
The third offense?
10/19/22. Meth, 5 years.
And the fourth offense?
It was 10/5 of 22, and that was another meth for 5 years.
So there were 4 separate offense dates,
Yes.
and the defendant was convicted on all 4 of those counts?
Yes.
And that was in the United States federal court?
Yes.
And he was sentenced to 5 years?
Yes.
Were those 5 years concurrent with each other?
Concurrent. Yes.
Were you able to find any other criminal history on the defendant?
There was one other offense, date 5/16 of 2012, casual exchange, a misdemeanor. He received a 6-month suspended sentence.
Your Honor, may I approach the witness?
You may.
Ms. James, can you identify the document that I just handed to you?
This is the pre-sentence investigation form that I completed and filed.
Thank you. And Your Honor, I'd ask that the pre-sentence investigative report be marked as Exhibit 1 in this hearing.
Mark it as Exhibit 1.
I will pass the witness.
Mr. Atchison, you may cross-examine.
Good morning, Ms.
Good
James.
morning.
Now, we've already established the fact that you were the one that prepared this report, correct?
Yes.
Now, as it relates to those convictions that were just mentioned, were you also provided with the report on that particular case?
Yes.
And Ms. James, you're also aware that this was all the same case, correct?
Yes, they were separate counts, same case.
Separate counts, same
Yes.
case. And as part of that report that you received on this federal case, this was, according to the report that you received and reviewed, this was an instance where agents used a confidential source in order to get these different dates, these different sale dates on these charges, correct?
Yes.
Now, outside of that case, you mentioned the only other thing that Mr. Day has in his history is a simple possession charge.
Yes.
Is that in 2012, correct?
Yes.
Now, did Mr. Day participate in this interview for the completion of this
Yes.
probation report? Is it your experience that defendants normally participate in the interview portion of this?
The majority of the time, yes.
And based on your report, you conduct what's called a strong R assessment, correct?
Yes.
Can you explain to the court where Mr. Day falls in accordance to that strong R assessment?
He scored moderate, which is in the middle.
And moderate,
Moderate risk for reoffending.
and just for purposes of clarification, what does moderate range generally entail as far as the recommendations?
Recommendations usually include programming, whether he serves prison time or on probation. It's different programs we recommend based off of the score.
Would those be cognitive behavior type
Yes.
recommendations or
Victim
courses?
impact, cognitive, behavioral, alcohol and drug, mental health, just whatever he needs.
And during your interview with Mr. Day, did he appear honest in his answers?
Yes.
That's all I have, Judge.
Any redirect? Thank you, Ms. James. You may step down and have a seat in the courtroom. Call your next witness. We won't ask you what you're placed under oath. I'm not going to ask you how fast you drove from Ashland City to here, so.
Good morning.
Good morning.
Thank you for being here. Lieutenant, will you state your full name, please?
It is Shannon Heflin,
And will you spell your last name?
Heflin.
Thank you. Lieutenant Heflin, you were a primary witness at the trial in this case, is that correct?
That is correct.
And you were the lead investigator or one of the investigators assigned to the death investigation of Mr. Jordan Knight.
Yes, that is correct.
You also, as I've already said, testified at trial.
I did, yes.
There were some questions that we could not ask at trial that I'd like to follow up on now at the sentencing hearing.
Okay.
Aside from the death investigation, were you a part of a group or team or task force that made some controlled drug buys from the defendant?
Yes, I was.
And you've heard the testimony of Miss Wendy James. The defendant was convicted on those controlled buys, is that correct?
That is correct.
I want to ask you just a few details about those purchases. How was that set up?
I guess we'll just start from the beginning. We reached out to some of our federal analysts and give them some of the phone numbers that we had and some of the names that we had involved, just trying to make a case on the overdose death of Jordan Knight. Probably a few weeks later, after getting that information entered into the federal database, we were contacted by the FBI out of Cookeville, Tennessee, and they had some interest in the suspect's name of Curtis Day in relation to a burglary theft case that had occurred out in East Tennessee, where some of the guns had reportedly made its way back to Day's residence on Germantown Hill.
Okay. From that, with that information, were you able to send a confidential informant into Mr. Day's residence?
Yes, we were able to come up with a confidential source. We introduced them to the FBI, and at that time we decided to go in and do some controlled buys.
The controlled buys were at Mr. Day's residence in Davidson County?
That is correct.
And it's the same residence that we heard testimony about in the trial
Yes, that is correct.
off of, is it Clarksville Pike?
Germantown Hill, Clarksville Pike, yeah,
Thank you. I believe it was trailer unit number 13.
I believe that's correct.
So the controlled purchases or controlled buys occurred in the same place in which drugs were sold to Mr. Jordan Knight.
That is correct.
We've also heard the name Amanda Gober.
That is correct.
Amanda Gober was living with the defendant at the time of Jordan Knight's death, is that right?
That is right.
Was she still living with Mr. Day at the time these controlled purchases were made?
Not at that time.
When the controlled purchases were made, was this done over a series of a couple of months?
Yes, there was, I think, maybe a total of 4 buys, controlled buys done.
And do you recall what type of drug was purchased?
Methamphetamine, crystal meth.
Methamphetamine. And were these purchases made directly from the defendant, Curtis Day?
They were all recorded on audio.
They were recorded in audio,
Yes,
and it was the defendant, Curtis Day.
yes.
Thank you. I'll pass the witness.
Mr. Atchison, you have questions?
Good morning, Lieutenant.
Good morning.
I'm going to get it right this time. I think I messed it up a few times during the
You
trial.
can call me Captain.
Now, again, just to reiterate, you testified during the trial in this matter, correct?
That is correct.
And you're well aware of the facts surrounding this case and also what was presented at trial, correct?
That is correct.
Now, you testified there were 4 separate controlled buys, correct?
That's my understanding, yes.
Out of those 4 controlled buys, were the drugs that were obtained during those controlled buys, were they tested?
After the control buys, all that was turned over to the FBI, so I don't think I can accurately testify that it was. I'm assuming that it was. I could sit here and assume that it was, but I wouldn't be able to answer that question 100% positive. But I'm going to assume that it was.
That would lead to my next question, which, based on that answer, you would have no knowledge whether or not those drugs tested positive for or contained fentanyl.
That is correct. I would not know that.
Now, these buys did occur in Davidson County, correct?
That is correct.
Which is exactly the same location where the buy in this case took place, correct?
Can you repeat that?
Those controlled buys took place in Davidson County, correct?
Correct, yes.
Which is the same, in this case, the buy or the transaction in Mr. Day's case occurred at the same location in Davidson County.
That is correct.
Now, General mentioned Ms. Gober, and she testified to it as well, that she had resided with Mr. Day, correct?
That is correct.
Now, when these buys took place, it was your testimony that she did not reside there. Is that correct?
During the buys with the feds, the
Yes.
FBI, no, she did not.
Was that based on the fact that she was incarcerated at that time?
I'm not sure if she was incarcerated or in the drug court program. I'm not too exactly sure where she was at that time.
But she was charged also in this case with Mr.
That
Day.
is correct, she was.
Lieutenant, at any point in time during the investigation, was Mr. Day interviewed by law enforcement for this case?
Briefly, maybe after the traffic stop, there was probably a brief interview.
Were any questions asked directly in relation to the case you were working with Mr. Knight?
I think that he may have refused to answer those questions at that time.
And you've had the opportunity to review Mr. Day's criminal history as well, correct?
Yes,
And you would agree he has no prior convictions for violent crimes, correct?
correct.
And based on the trial and your investigation in this matter, you're also well aware that there were several inconsistencies with certain testimony. Would that be accurate?
you'd have to explain that a little bit better.
In more specific terms, you recall Tristan Matthews' testimony, correct?
That is correct.
And you would agree with me that there were several inconsistencies in Mr. Matthews' testimony
I would agree to that.
based on your
Yes.
conversations with him and
Yes.
your investigation? Judge, I'll pass it.
Redirect.
Lieutenant, concerning Tristan Matthews' testimony, Mr. Atchison did a good job of cross-examining him at trial, but there were some things that did not come up that were left out about Tristan Matthews. For example, Tristan Matthews actually had disclosed, and it was noted in a report, that he had tossed some of the drugs that were purchased on the ground on the night of the event.
That is correct.
And that's actually noted in a Cheatham County Sheriff's Office report.
Yes, that's correct.
And Mr. Atchison didn't ask him about that. Thank you.
Recross.
Lieutenant Heflin, at any point in time during your conversations with Mr. Matthews, did he indicate to you that there was ever a second bag or a different drug that was
did.
purchased?
He did not.
And so, if in fact his testimony was accurate and the report he initially gave to you, then we have no idea where that second bag of narcotics came from, do we?
No, we do not.
No further questions, Judge.
Anything further? Thank you, Lieutenant. You may step down and have a seat. Call your next witness. State has rested their proof, Mr. Atchison. Do you wish to offer proof at the sentencing level? Okay, you want to call that witness, then bring him in. You step around here, please. Raise your right hand and face our clerk.
I do.
And Mr. Tanksley, as General Crouch pointed out, there is a microphone if you'll try to speak directly into that. If you would, state your name for the court.
Isaac E. Tanksley Jr. Jr.
Maybe not that close, but that's good. Now, Mr. Tanksley, how do you know Mr. Day?
He is my nephew by marriage, my wife's sister's son.
And just briefly, if you would, tell the court your connection with Mr. Day as far as his upbringing.
Curtis, can you hear?
So-
Curtis has spent relatively all his life with us. We actually babysat him at birth, and my wife was very fond and close to him, all of us, from birth to 4 years old. That's when his mother moved somewhere in that time frame, maybe 6 years old, moved off to California, and me and Lisa stayed connected with Curtis through the years. She was really close to him, like a mother, and I was always right by his side too. But I'm kind of a more tough love type person, so it's our relationship was more manly than it was. I mean, I love Curtis. He's always been a good person, but he's had this demon that he's battled with for his whole life, and we've just kind of stuck by him, and that's what you do with family. And so anyways, we've just always known him. I've known him throughout his whole life when he was from birth until now. I'm here now, so whatever I can answer.
What can you tell the court about Mr. Day's employment history?
Curtis has always been a hard worker. He took a job at a local grocery store in Nashville. I don't know if anybody knows the area, H.G. Hill Groceries. He went there when he was 14, 15 years old and worked there, and off and on with me. I run a tree service, and he's worked with me off and on through the years. And once he got of age, graduated from school, 18, 19 years old, he started doing central heat and air work, and he kind of made that a career. But it was obvious that Curtis had a demon or a monkey on his back, and just sort of dealt with that like a lot of people do throughout the years. And we just sort of loved him and stuck by him, and tried to do what we could to, stand by family. That's what you do.
And as it relates to those demons, can you sort of elaborate a little bit, if you will, for the court? Are we talking about addiction, substance abuse?
Yes, I didn't really know exactly what it was and to what extent, but you could tell when there's issues in people's lives, they seem to never have enough money at the end of the day or at the end of the week, and they just they're backwards and withdrawn from social environments. So it's just it was obvious that there was something there, and he worked hard and took raised his family. He took on a family and raised them, and was doing whatever he was doing. And then in 2010, me and my wife were in the flood, and Curtis like I said, he was doing central heat and air work. He come in, helped us out with that, and I could tell that during that time that the drug addiction or abuse had escalated, and it kind of drawn a wedge between me and him with that tough love that I was talking about. He knows that I'm sort of a no-nonsense type person, big heart, but not good patience. So anyways, he helped us through that. And after that deal there with him helping us out with our central heat and air, we kind of lost contact. And the next thing I heard from Curtis was a couple of years later, and he'd kind of hit rock bottom, went through a divorce, and I think that's when he got that charge. And we didn't know anything about that, but when he come back into our lives full stream, we could tell there was a problem there. And I took him to the mission, and it was like, hey, here's the best place I know for you to get help. It wasn't, I think he'd been searching for help and reaching out, and there's not a lot, if you don't have the right resources, there's not a lot there for certain people. So anyways, I took him there, and I was just like, this is the best I can do for you, and give me a call and let me know how it works out. So he went into their life program, spent some time there, got out, went into a halfway house, come back to work for me for several years there. I mean, I guess it was up until the time that he was gone, up until this all happened, he was working for me off and on. But I think he was trying to get himself back into the central heat and air. I mean, tree work is not something that you want to be doing for a career your whole life unless you're just blessed or lucky like I've been. So anyways, I think he was getting back into the central heat and air, and I could tell that he was slipping, and I had talked to him about that. And I don't know if y'all have dealt with that, but it's hard to talk to somebody that's they're just tunnel vision on that addiction, and it's hard to get through to them. All you can do is just pray and love on them and hope there's intervention there.
And during that time, you and your wife continued to support Mr. Day?
Oh yeah, as much as possible. Like I say, that my wife, she's sort of not here today because it's just too much of a drain on her. She just don't have the emotions for it, and it's hard being here. But I talk to him, and it's hard for one grown man to get through to another, especially when you take such a strong stance that I do. You know, it's easier to deny and avoid than it is to just face your demons and work on it. So anyways, yes, I'm always been there for them, and guess I always will.
Is there anything else, Mr. Tanksley, that you'd like the court to know or hear about Mr. Day?
Other than the fact that, we all have issues and problems, and as far as I know, he's always been a good person and just, not really, the picture can be painted a lot of different ways, but he's, he has a lot of good in him. That's all I can say.
I'll pass the witness, Judge.
Thank you, Mr. Tanksley. You may step down. You have anything further, Mr. Atchison? Say you have any rebuttal proof you wish to offer? Then I'll hear you in argument.
Your Honor, I think that Ms. Williamson's testimony and Mr. Tanksley's do an excellent job of reflecting the type of cases that Your Honor, all of us in this courtroom see on a daily basis, that it's devastating what addiction to drugs can lead to and how it can destroy families on both sides of this case, the victim's family and the defendant's family. Aside from that, Your Honor, I am standing before the court asking for you to consider 3 enhancing factors that the state has filed. The first of which is that the defendant has a previous history of criminal convictions and criminal behavior. It is undisputed that Mr. Day, the defendant, is a range 1 offender. So we're asking the court to consider the sentencing alternatives within his designated class as a range 1 offender. The second factor is that the defendant was a leader in the commission of an offense involving 2 or more criminal actors. The defendant, in his statement to Ms. James, acknowledges that at one point Amanda Gober was living with him. And Your Honor heard the testimony of Amanda Gober at trial. Her testimony, and I'm paraphrasing, was essentially that she was the use a different word, conducted the transactions on behalf of Mr. Day. That she lived with him. Essentially, she was addicted to drugs as well. She did things for him that she didn't like to do, sexual things, was her testimony, in order to get drugs from the defendant. And this included going out from his trailer and delivering drugs to the customers of Mr. Day. She and he made up a team of players that were actively involved in the sale and distribution of methamphetamine and fentanyl. And the final factor I would ask the court to consider is that the defendant had no hesitation about committing a crime when the risk to human life was high. This case is a perfect example of that, Your Honor. Mr. Jordan Knight succumbed to his use of drugs and the sale from the defendant on October the 3rd, 2020. These 4 transactions after that you've heard testimony about all range from October and November of 2022. So the defendant was aware of Mr. Knight's death and yet continued to participate in this type of activity, which is a very high risk to human life. You heard Ms. Gober's testimony at trial that the defendant had been engaged in that type of activity leading up to October the 3rd, when Mr. Jordan Knight was sold this combination of meth and fentanyl. This activity, the sale of a Schedule II drug, is one of the highest risk behaviors to human life that there can possibly be, because the dealer and the victim have no idea what exactly is in that combination of drugs that they're selling. There can't, to me, other than just facing the barrel of a gun, this is one of the most risky behaviors to human life possible. And we're asking the court to assign great weight to that factor. Thank you.
Mr. Atchison?
Your Honor, we stand here today in a case that involves a terrible loss, a young life that was cut short, and no sentence imposed in this courtroom will ever erase that tragedy or heal that pain felt by either one of the parties' families. I'd like to begin by acknowledging that loss and say that nothing that I say here today or anybody else is meant to minimize the harm or the hurt that has resulted from this particular act. But Judge, sentencing also requires the court to look at the whole person standing before you, not only the offense, but also the circumstances, the history, and the future potential of the defendant. The law in Tennessee directs you to fashion a sentence that is just, that protects the community, but that is also no greater than necessary. General Crouch has already acknowledged that Mr. Day is a range 1 offender. This particular offense carries a significant penalty. For range 1, it's 15 to 25 years within Mr. Day's range. We're asking this court to impose the minimum sentence available, 15 years, because the mitigating factors that I have filed, I would submit, strongly outweigh the aggravating ones. Judge, the first one being that Mr. Day has a limited criminal history. Aside from the federal case that has already been adjudicated, he's not a career offender. He's not a person that, by any testimony or evidence that's been presented, has spent his whole life trafficking drugs for profit. Second, Judge, this offense arose out of tragic and unusual circumstances. General Crouch himself just stated that there's no way for Mr. Knight or Mr. Day to have known what was in that illegal drug that he voluntarily purchased and used. I don't know how we would assess that in any setting. But just like Mr. Knight, Mr. Day sits here today, like so many others in our community, he struggles with addiction. Drugs were shared or provided in that context. There was never anything on record or through testimony to prove he intended to harm Mr. Knight. It wasn't with malice, and certainly not with the knowledge that this young person would lose their life. That doesn't excuse what happened, but it helps us explain it. PSR report, Judge, also indicates a history of mental health issues that Mr. Day struggles with. Even still today, incarcerated, he's on certain prescriptions for mental health and depression. Of course, that could easily be in connection with where he's at and the situation. And last, Judge, as it relates to the catch-all factors, the circumstances of this case, including his history, would support the inference that the defendant's underlying issues with substance abuse and his own personal dependency should be considered in mitigation. Along the same lines with the PSR report, Judge, while incarcerated, Mr. Day has shown that he has the initiative to do better, to change. He's received certificates in HVAC, plumbing, and electrical trades. He's making use of his time to better himself and in hopes of being a productive member of society once released. It shows that he has the desire and aptitude to reform. And Judge, Mr. Day is more than his worst mistake. He's a father, a son, a nephew, someone whose life has value, and whose future does not have to be defined by this crime. Heard testimony from his uncle, Both his aunt and his uncle have been supportive. They've been to every one of these hearings. He testified today, Judge. And again, I don't want to take away from the grief that was expressed through Ms. Williamson's victim impact statement. And I, for one, am not asking this court to overlook their pain. We are, however, asking the court to recognize that a 15-year sentence still provides real punishment, still provides deterrence, it still protects the public, but it also leaves that room for redemption. So, Your Honor, we would respectfully request that you impose a sentence of 15 years, the minimum within the statutory range. The sentence is sufficient, but not greater than necessary to achieve justice under the law.
Mr. Crouch, anything further? Let me start by acknowledging one thing. Mr. Atchison has been appointed by this court to represent Mr. Day due to, I think, a conflict in the public defender's office. And I will compliment Mr. Atchison on the very credible and fine job he's done in representing Mr. Day and as competently as we could have hoped to have someone represent him. And I certainly understand and appreciate his position, having been there many times myself. And speak up if you want me to hear it. Oh, well, I'm sorry. I thought you had concluded your proof. Then let's let him come up and we'll have that statement before we move forward. So he needs to come to the stand. Let's come to the witness stand, if you will. I'm going to take back what I said about how good a job you did if you're going to let me slide by that. Mr. Day, you are making an allocation, if I understand, allocution rather, so I'm not having you placed under oath, but I'll allow you to have your statement.
Your Honor, and to the family of Jordan Knight, I want to begin by saying how deeply sorry I am. I know that nothing I say today can bring Jordan back or ease the pain you have suffered. I take all responsibility for my part in what happened. I will live with that for the rest of my life. I never intended for anyone to be hurt, but I know my choices and had tragic consequences. I understand that. Since my arrest, I have tried to face what I've done and work on myself. I've been working on bettering myself by completing courses in HVAC, plumbing, and electrical trades so that I can hopefully be a productive member of society after I'm released and putting my addiction and substance abuse behind me. I am committed to changing my life so that like nothing this ever happens again. I know that I cannot undo my past, but I hope one day I can do something positive with my life that in some way portrays a better version of me. I'm truly sorry for your loss, and I thank the court for allowing me to speak.
Thank you. You may step down. Mr. Atchison, is there anything else of any source that you wish to have me consider? Now, I'll give you one last chance, General Crouch. Anything else you want to say? Sentencing in these types of cases is never easy. There basically is a tragedy that affects both sides of the equation in this situation. Drugs and drug overdose deaths and the continuing problem that we have with the drug issue in this county and Cheatham County and 23rd Judicial District, the state of Tennessee and the United States presents one of the most difficult things to deal with because people desire to use these drugs without consideration. I agree with Mr. Crouch in that it is a highly, highly dangerous activity to engage in when people put into their bodies something that they have no idea what it contains. And they are simply rolling the dice, or it's almost like Russian roulette to use drugs when you don't know what it is, and especially with the fentanyl that has come about. So it's a continuing problem. It affects families across generational lines, across socioeconomic lines, families throughout the area. Even my own extended family has been affected by these kinds of things. So I certainly understand the problem and how things can escalate sometimes for a person. So I understand both Mr. Day's situation as well as Jordan Knight's situation. I am required to impose a sentence based upon the findings of our jury in Cheatham County that found Mr. Day guilty of the second-degree murder. Second-degree murder, as we've had explained, for a range 1 offender, and it is established that he is a range 1 offender, carries a sentence of 15 to 25 years. In order to determine the type of sentence, he is not eligible for probation, so that is not an option that would even be considered by the court if it were available, but it is not available as an option. As a result, then the court has to consider the sentencing considerations that are set forth in our Tennessee Code. I cannot just set the sentence that I think is appropriate no matter what the range. I must follow the sentencing guidelines that our state legislature has imposed, or has implemented rather. And under Tennessee Code annotated 4035-103, those sentencing considerations include the following. Sentences involving confinement should be based on the following consideration. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence to those likely to commit a similar offense. Are measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purposes of this chapter should be avoided. Sentence imposed should be the least severe measure necessary to achieve the purpose for which the sentence is imposed. The potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative. I don't believe an alternative sentence is available or appropriate in this case. So considering those sentence considerations, mostly those that deal with whether or not a person should be incarcerated or not. In this particular case, because incarceration is mandated by the length of the sentence, that a minimum sentence, have to determine what the overall sentence should be. That will be determined by looking at both the mitigating factors and the enhancement factors. I'll start, since the state goes first, with the enhancement factors. The state has raised as the enhancement factors, number one, these are set forth under 4035-114 of the Tennessee Code. Subsection 1 of that is the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. This is a little bit tricky because the convictions that he has are post-dated or occurred after the conviction that he has, or after the offense date of this. In other words, the offense date in this particular case is from October the 3rd, 2020. That is the crime for which he has been convicted and which I am sentencing. The crimes that the state has introduced and the pre-sentence report has picked up are offenses which occurred in 2022, which obviously occurred after the date of this. And as a result of that, there's some question in my mind as whether those constitute a previous conviction or a previous history of criminal convictions. In other words, they certainly are predating the sentencing hearing today, but whether those convictions will predate, constitute a previous history, it concerns me that would be an applicable provision. The second factor that the state has cited is that the defendant was a leader in the commission of an offense involving 2 or more criminal actors. I certainly find that to be the case. As the testimony has established and as General Crouch pointed out, this woman that was involved in this case, her name was Amanda Dover, if I recall correctly. was used as a go-between to insulate Mr. Day from direct contact with the people who were buying the drugs. That he would sell the drugs to her supposedly, and then she would deliver the drugs. She indicated she got the drugs from Mr. Day, and that she then delivered them to Mr. Knight, and that's how the jury found that he was responsible legally for the death of Mr. Knight. So I find that to be a factor that is applicable. The third factor that the state, and I agree that the state, that none of the other enhancement factors would have seemed to apply except for number 10. The defendant has no hesitation about committing a crime when the risk to human life is high. As I stated at the outset, and as the state has made a point, and even as Mr. Atchison on behalf of the defendant has pointed out, the risk to human life in selling drugs such as this is extremely high, and the defendant engaged in the sale of drugs. I am considering the evidence of the convictions that he has in federal court of selling drugs that occurred, I think it was 4 different convictions for the sale of drugs that occurred, as I've stated, after this, because those represent the fact that Mr. Day, even despite the fact that Mr. Knight passed away as a result of the drug use that Mr. Day was involved in, continued to engage in an activity that created an extremely high risk for the lives of other people. And I think that factor is applicable because I think those subsequent convictions reflect that the fact that at the time of the sale to Mr. Knight, or to Ms. Dover to Mr. Knight, that he clearly had no hesitation about committing these crimes, selling these drugs. It's one thing to use drugs yourself, and unfortunately Mr. Knight had a need or a problem with the use of drugs. It is quite another, to be a dealer who distributes drugs into the community, and those drugs then cause suffering among the general population, as well as the death of Mr. Knight and others, potential victims. So I found that is a factor. So I'm ascribing, or I'm assigning great weight to the second factor, that he was a leader in the commission of the offense, and to number 10, that he had no hesitation about it. I am not assigning great weight to the first because of the fact that I still have questions as to whether those convictions that occurred subsequent to the date of this offense could be considered as a factor. In looking then at the mitigating factors that the defense has provided, there is a minor role. The first that they cite is a minor role in the offense or lack of direct involvement. And it states that the instant conviction involves a sale or distribution of narcotics that resulted in death. If the defendant's involvement was indirect or peripheral as it relates to the distributor. That's taken from Mr. Day's own statement to the probation officer, Ms. James, who took a statement from him in which he says, I don't know if they were the drugs I sold or not. I didn't have any direct contact. I didn't sell them to him, which obviously reflected a lack of remorse and a lack of acceptance of responsibility. Obviously, that has changed since he gave her that statement, because his testimony or his statement today is he accepts responsibility. So I do not find that to be a factor. I don't find him to be a minor role in the offense. I find him to be mainly responsible for it. He was the dealer who sold the drugs. Number 2, reduced culpability due to substance abuse and mental health disorder. I also do not find that having a long history of substance abuse, should be considered by this court in reducing his culpability for causing the death of another individual. If anything, his own substance abuse ought to ward him away from trying to sell drugs to other people. Unusual circumstances and lack of sustained intent to violate the law. Says the allegation is the defendant did not commit a typical act of violence, rather a homicide conviction stems from an accidental drug overdose. You can make that argument, but the state legislature of the state of Tennessee has rendered a statute that he was convicted under that simply says it is second-degree murder to sell a drug that causes the death of another individual. Period, exclamation point. So I don't find that to be a factor that's applicable. The defendant's conduct was substantially influenced by his dependency on narcotics. This is under the catch-all provision. The circumstances, clearly there might be some factor there that would have some influence, but I mean, I'm sure that his own dependency, as his uncle testified to, contributed to the fact that he was, trying to make money because he probably couldn't make it any other way, since he had a drug addiction. Number 5, the defendant's rehabilitation, potential, employment history, education. I don't really find that to be much of a factor because the sentence length, the minimum sentence length here is quite lengthy, 15 years, and therefore I don't find that the rehabilitation aspect is really appropriate. There is no sentence that I can impose in this case that's going to heal the suffering that Jordan Knight's family has had or ease the pain that is felt by Mr. Day's own family, extended family. That the sentence that I have to impose has to reflect the reality of the fact that we have a drug problem in this country and in this state and in this district where people are dying as a result of this drugs being sold. And as was stated at the outset, one of the considerations I have to follow is the fact that the sentence imposed should send a message to those individuals who might be otherwise engaged in or contemplating engaging in the sale of drugs. For that reason, I find that the sentence imposed on Mr. Day that he should be sentenced to, and I hereby sentence him to 22 years in the Tennessee Department of Corrections. That sentence is less than the maximum, but more than the minimum, and it recognizes the issues and those factors that I have set forth and gives weight to both the enhancement factors as well as the mitigating factors that were cited in this case. I'm truly sorry for the loss that the Jordan Knight's family has suffered, and for the pain that Mr. Day's own family is going to suffer as a result of his incarceration. Perhaps this sentence will dissuade others who might be inclined to engage in such activity from doing so. That is the judgment of the court in this case. Mr. Day is remanded to the Department of Corrections to serve the 22 years. As a range 1 offender, his serves the 30% release eligibility, correct? Or no, this is 100%? It is 100%, right, I forgot. Because of the statute that he was convicted under, it's 100%, so he'll have to serve the 100% of the 20 years. All right, 22 years. Ms. Misty, thank you for all of your help. I'll give you back this file. I think I just giving you back that everything you had, right? Something back. All right. My understanding is that the next case we're going to take up is the State versus Gregory Arnie Hansard. Is that correct?
Client this morning, and he told me that he is in a hospital or a clinic right now due to a blood sugar issue.
Due to what?
Due to a blood sugar issue, and I asked him to send written confirmation from that facility to me. I have.
Well, this is a 412 motion. Is this case set for trial?
Yes, sir.
When is it set?
January 29 and 30.
All right, so we've got time to reset these motions. You want to go ahead and select a date for that?
Please.
This is State versus Gregory Arnie Hansard III, 2023 CR 336. And you get them all? Sorry. Well, his trial date is January. I assume you would like to have that heard before.